right after law school, I had a couple different thoughts about what I might want to do. One was to do appeals at a big firm. But then I also got the idea in my head that after seeing so many federal appeals cases that there might be a way to go on my own and start my own practice focusing on that area. Being a solo, you have this conflict or kind of two issues going against each other. And one is you're, on the one hand, desperate for work because you've got to survive and you've got to make sure that you survive and can pay the rent and your practice works. At the same time, once you get the work, you're kind of, you can have a concern about who's going to do it all because it's just you. And so it's not so simple as bring in a ton of work and then disperse it among all your people. If it's just you, once you bring in something that takes a lot of time, other things have to be put on the back burner. And it's a very difficult problem to resolve because when an interesting case comes along, the last thing you want to do as a solo is say you can't do it or turn it down. And so part of what you try to do is balance the timing so that you can focus on one thing, maybe get an extension on another. A lot of people, when I said I was going to go as a solo and then start a solo practice, one of their main thoughts, and frankly one of mine, was is it going to be too isolating? Am I going to be sitting in my office by myself day after day, just reading and writing briefs? And the truth is, it's sort of surprising to me as well, is that I think I've had actually more interaction with other attorneys and people outside of the office than I would have maybe at the larger law firms. I find myself interacting with all kinds of different people, and because my practice is appeals, it spans criminal and civil, which puts me in touch with entirely different sort of segments of the legal world. You know, the practice is really based on federal appeals, and that's the focus of what I do. What that means really is a lot of constitutional law and a constitutional litigation. In the federal courts, federal appeals courts, you have a lot of federal crimes, death penalty litigation, and then a number of civil rights type cases. I've decided to focus on appeals for really a couple reasons. One is that I do enjoy the appeals work. I've always thought it was interesting for a couple reasons. One is that you cover a couple different areas of law. It's not limited to, let's say, criminal work or constitutional, civil rights type things. The other is that to the extent you're litigating in federal appeals courts or even the Supreme Court, you're of course dealing with issues that can establish pretty important precedent. It can have a pretty big impact beyond just that case. The other thing about appeals that for me made it a particularly good focus in terms of solo practice was that you don't necessarily need an army of attorneys to handle an appeal, especially if you have the background experience to understand how briefs are supposed to look and how an oral argument should be constructed. In other words, while you might need a team of 8 or even 80 lawyers at the trial level to go through tens of thousands of documents and to construct a lengthy trial strategy and things like that, once you get to appeal, the court is obviously limited to a great extent by the record that's already been created. And so it's amenable to a solo practice. Well, I was sitting here in my home office. It was a Friday in October, and the phone rang about 1 o'clock in the afternoon. It was an attorney I had done some work with, and she said that Michelle Ortiz had been calling, somewhat frantically calling anyone she could think of from the phone book to take her case or help her. And once I learned more about it, I realized it was a Section 1983 civil rights suit, and she had lost in the Sixth Circuit and was seeking any possible way to try to get to the Supreme Court. And I looked up the case, and then once we did some calculations, I realized that the deadline for her to get any sort of extension to petition in the Supreme Court was actually that day. So we put the motion together, got it in, and fortunately, about 2 weeks later, or maybe less, we got the motion granted, which meant that the case was still alive. Once I started doing some research, I came across a procedural issue that I started to realize was being treated differently across the circuits. So there was a circuit split on the question, and that was what I decided had to be the way we would go with the petition to have any sort of shot whatsoever. And so spent a lot of time putting it together, and the more research I did, the more I realized that there was a real important issue here that could affect all kinds of civil cases, because it is a question of appealing summary judgment denials, which occur all the time. One day in April, the order list came out, and you know, I guess lightning sort of struck, and the court, for whatever reason, believed that this was a question they wanted to take on, and so the case was granted, and all of a sudden, I was basically in the Supreme Court.